welcome to all. As a part of the course on Insolvency and Bankruptcy Law in India, today we are going to discuss the concept of public announcement, filing of claims and verification of claims. As already we have discussed, once the application is admitted by the adjudicating authority, that is the petition, the application is made by the financial creditor, operational creditor and corporate debtor. If it is admitted, then IRP will be appointed. Then he is supposed to make the public announcement. Okay, so today we are going to discuss how to make the public announcement, what is the format for that. Then when IRP is filing a public announcement, then he is going to invite the claims from the creditor and verification of the claims is also done. So today in this lesson we are going to discuss what are all the formats to be used for the public announcement, filing of claims and verification of claims. So section 13, declaration of moratorium public announcement, so which provides that the adjudicating authority after admission of the application under section 7 or section 9 or section 10 shall by an order declare a moratorium for the purposes referred in section 14. So already in the previous classes we have discussed the scope of the section 14. Then cause a public announcement of the initiation of corporate insolvency resolution process and call for the submission of claims under section 15. So once the CRP process is started, okay, he is going to do the public announcement for the initiation of CRP process and call for the submission of claims under section 15 and appoint an interim resolution professional in the manner as laid down in the section. So once the adjudicating authority admits the application under section 7, 9 or 10, then first we are going to make the declaration of the moratorium, then we are going to make the public announcement for the initiation of insolvency resolution process and we are going to appoint the interim resolution professional. Okay, so these three things will happen when the application is admitted by the adjudicating authority. The public announcement referred in clause B of subsection 1 shall be made immediately after the appointment of interim resolution professional. So once the interim resolution professional is appointed, immediately you are going to make the public announcement. Then let us discuss section 15, public announcement of insolvency resolution process. The public announcement of the corporate insolvency resolution process under the order referred to in section 13 shall contain the following information. So whenever you are making the public announcement, these details must be there in the public announcement. Okay, the name and address of the corporate debtor under the corporate insolvency resolution process, name of the authority with which the corporate debtor is incorporated and registered, then the last date of submission of claims as may be specified, then details of the interim resolution professional who shall be vested with the management, because once the CRP process started, you are going to appoint the IRP. So who is going to replace the board of directors, okay, and be responsible for receiving the claims, because he is the person who is going to receive the claims. Okay, these things must be there in the public announcement. Okay, and penalties for false and misleading claims, if any, and the date on which the corporate insolvency resolution process shall close, because time limitations are there, when the CRP process is going to be completed, when it is going to be closed, which shall be the 180 days from the date of admission of application under section 7, 9, 10. Okay, so under the act, CRP process must be completed within a period of 180 days. Okay, but anyway, we are going to discuss in the another lesson where how we are supposed to complete within the time limitation, whether the judiciary is having any power to extend the time limitation, whether practically, whether are we able to complete within the time limitation or not. Okay, so we are going to discuss in another lesson. Then filing of claim by the creditor. So once if you make a public announcement, okay, the purpose of the public announcement is to invite claim from the various creditors. So why we are giving the public announcement? Okay, so the basic purpose of giving the public announcement is that we are going to invite the claims from the various creditors. Then what is the claim? Okay, claim is defined under section 3, subsection 6, which means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. So whenever I'm having a right to payment, so this definition already we have discussed in the previous lesson. When we are discussing the definitions part, we have discussed the definition of claim in detail. In a simple language, whenever I'm having a right of payment, okay, so that right to receive the payment, maybe that is reduced to the judgment. Maybe I have received the judgment. Based on the judgment, I am having a right to receive the payment. Okay, it is fixed, or it may be disputed or undisputed, secured or unsecured. Okay, so right to receive the payment is one claim. Then right to remedy. Okay, so under the claim, we are supposed to highlight 2 points. Okay, right to payment and right to remedy. So right to remedy for the breach of contract under any law for the time being in enforcement. So whenever you are having a right to remedy, okay, so suppose if opposite person is failed to perform his contract, then you are having a right to remedy. You can go to the court of law. Okay, so that is right to remedy. So whenever I am having either right to payment or right to remedy, then that is called as claim within the meaning of section 3 subsection 6. Okay, then filing of claims by the operational creditor other than the workman and employee. Okay, so before that, let us discuss how to make the public announcement. Okay, so I'm going to show you the format for public announcement. Form number A. So in form number A, you are going to make the public announcement. Okay, so this is the format for form number A, schedule 1, form A, public announcement. So the details, these are all the various details to be given. Okay, so name of the corporate debtor, date of the incorporation of corporate debtor, authority under which corporate debtor is incorporated, corporate identity number, LLP number. So in case of company, SIN number will be there, LLP identification number will be there, address of the register office of the principal office, insolvency commencement date, estimated date of closure of insolvency resolution process. Okay, so as already we have discussed in the section, these are all the basic details. Okay, name and register address of the registration number of insolvency professional. Okay, address and email of interim resolution professional, email to be address and email to be used for correspondence, last date of submission of claim. Okay, so classes of creditors if any under class B. Okay, name of the classes, how many classes you are having, names of insolvency resolution professional, okay, along with their identification number and relevance form. Okay, these are all the basic details to be given in public announcement. Okay, this is the format number 1. Okay, so in this format, you are supposed to give the public announcement. Then, so once if you made the public announcement, various categories of creditors, they can claim, they can submit the claims. Okay, now let us discuss. Okay, so one by one, various categories are there. One by one, we are going to discuss. Okay, so filing of claims by the operational creditors other than the workman and employee. Okay, so regulation 7 of the insolvency bankruptcy, insolvency IBBA, insolvency resolution process for corporate person regulations 2016 provides for claim by the operational creditor other than the workman and employee. Okay, so here we are having one format, form B. Let us look at regulation 7 and regulation form number B. Okay, regulation 7 speaks about claims by the operational creditor. So according to regulation 7, a person claiming to be operational creditor other than the workman or employee of the corporate debtor shall to the interim resolution professional by post or by electronic means in form number B. We are going to look at the form number B also. He is supposed to submit the claim. Okay, so what to be given along with the form number B? So records available with the information utility, if any, other relevant documents like contract for the supply of goods and services with corporate debtor, an invoice demanding payment for the goods and services supplied to the corporate debtor, an order of the court or tribunal that has adjudicated upon the non-payment of debt. So you are supposed to provide the contract of supply because operational creditor must have supplied some goods or services, rendered some services. So contract for that, invoice. So as already we have discussed previously, the operational creditor is supposed to demand. Okay, so he is supposed to demand payment of the receipt from the corporate debtor before filing a petition. So an invoice demanding the payment and an order of the court if any, and financial accounts. Okay, then you are supposed to give copies of relevant extract of the GSTR1. Okay, so you are supposed to give GSTR1 and GSTR3B. Okay, so you are supposed to give these data. Okay, then provisions of the relevant laws relating to goods and service GST Act, then e-way bills if any. These are all the basic documents to be given along with the form number B. Now look at form number B, schedule 1, form number B. Proof of claim by operational creditor except workman and employee. So to the interim resolution professional, it is in the format of letter. To the interim resolution professional, these details must be given. Name of the operational creditor, identification number of operational creditor. If an incorporated body, provide identification number and proof of incorporation. Suppose if it is a company, certificate of incorporation must be given. Okay, LLP certificate must be given. Address and email address of the operational creditor for the correspondence. Total amount of the claim. Details of the documents by the reference number. So you are supposed to submit the claims along with the reference numbers. Okay, claim number 1, claim number 2 for this attachments. Okay, then details of any dispute as well as the record of the pendency. So if in case of any disputes are there, you are supposed to give the details of the disputes also. Details of how and when debt is incurred, and details of any mutual credit, and details of these things. Okay, any security held, the value of the security and its date, any retention of title arrangement. So these basic data to be given along with the form number B. Okay, then details of the bank account to which the amount of the claim or any part thereof can be transferred. Okay, list of documents attached. So these are all the basic documents, and after that you are supposed to give the declaration. Okay, so these documents must be attached along with form number B. Then subsequently we will discuss filing of claims by workman and employee. So regulation 9 of the CRP regulations deals with filing of claims by workman and employee, read with form number D. In form number D, so proof of claim by workman or employee, then here they are going to give the details of name of the employee, workman, PAN number, passport, the identity card issued by the Election Commission, Aadhaar card, any ID card, address and email address of the workman, employee, total amount of the claim, how much amount you are claiming, details of documents by the reference to which the claims to be submitted, substantiated, details of any dispute as well as the record of pendency, details of how and when claim arose, then details of any mutual credit, mutual debit, debts or other mutual dealings between the corporate debtor and the creditor, then details of the bank account, list of documents. Okay, so these documents must be given in this form. Then let us discuss about filing of claims by financial creditor. The filing of claims by financial creditor is discussed in regulation 8 of CRP regulations. In form number C, he is expected to make the application. Now let us discuss filing of claims by financial creditor. Regulation 8 of CRP regulations deals with filing of claims by financial creditor. The creditor is expected to make an application in form number C. Submit the claim in form number C. Let us look at form number C. Schedule 1, Form C provides for submission of claim by financial creditor. Here financial creditor claim in form number C. These are all the basic details. Name of the financial creditor, identification number of financial creditor, if it is an incorporated body, SIN number, partnership form, individual, you are supposed to give the data accordingly. Address and email address of the financial creditor for the correspondence. Details of the claim compared with the operational creditor, the details he is expected to give in detail. Amount of the claim, amount of claim covered by the security interest, then amount of claim covered by the guarantee if any, name and address of the guarantors. So these data must be given. Then details of claim if it is a made against the corporate debtor as a guarantor, if he has given the guarantee, a financial creditor has given the guarantee, then amount of claim recovered by the financial security interest, then amount of claim covered by the guarantee, name and address of the principal borrower, then amount of claim if it is made in respect of financial debt, then details of how and when debt is incurred, details of any mutual credit if any, and bank account details. Okay, so then you are supposed to give the declaration. This is how you are going to submit your claim. Regulation 8A of CRP regulations provides for filing of claims by financial creditor in class. So form CA is a relevant form for filing of claims by financial creditor in class. Here this is how he is going to file the claim. Name of the financial creditor, identification number of financial creditor, more or less similar facts are in case of incorporated body, SIN number, partnership form, registration number, LLB registration number. Then address and email address, total amount of the claim, details of the documents, details of how and when debt is incurred, then details of any security held, and details of mutual credit if any, then details of bank account, list of documents. Okay, name of insolvency professional who will act as authorized representative. Okay, so in case of class, as already we have discussed, the class cannot represent themselves, so they should be represented by authorized representative. Okay, so in case of insolvency professional, who will name of the insolvency professional who is going to act as a authorized representative of the creditor. Okay, then you are going to give the declaration. Power of interim resolution professional or resolution professional in relation to claim filed by the creditor. So as per section 18 subsection 1 clause B, IRP is duty bound to receive and collate. Please remember the words receive and collate are very important. He is expected to receive the claims and he is expected to collate. So this is what basic duty of the interim resolution professional. Okay, all the claims submitted by the creditors, as already we have discussed. So various forms are there. In these various forms, he is supposed to receive the claims, then collate all the claims submitted by the creditors to him pursuant to public announcement made under section 13 and section 15. So in the case of Bijay Prabhakaran Pulipra, RP of PVS Memorial Hospital Private Limited versus State Tax Officer, Works Contract, CGST Department, NCLAT held that the RP may under Regulation 10 call for clarification. Suppose when you are submitting any claim, if he is having any doubt or if he requires any clarification, RP is having power to ask for clarification for substantiating the whole or part of the claim. Okay, so for each and every part, because you may claim 2 to 3 amounts. Okay, so for each and every claim he can ask for information for substantiating the claim. Then in another case la, Sumat Kumar Gupta, RP of Vallabh Textiles Company Limited versus Vardhaman Industries Limited. In this case la, NCLAT held that the RP or IRP shall maintain an updated list of claims. So it is the responsibility of resolution professional. So whenever they are submitting the claims, he is supposed to maintain one register. So in this register, he is supposed to update the claims. Okay, the RP while examining claims expected to act in a manner which inspires confidence in the financial creditor. So he is expected to act in such a manner in good faith. In a simple language, in good faith he is expected to act, and he is not expected to do anything which is prejudicial to the interest of creditors. Then in another case la, Earth Gracia Private Limited versus Earth Infrastructure Limited. So in this case la, NCLAT held that supported the decision of RP to reject the claims on the basis of documents. Okay, so RP is having freedom. Okay, when claims are submitted to the resolution professional, okay, so if any claim is considered to be fraudulent, okay, if he is of the opinion that any claim is fraudulent, then in such cases resolution professional is having a right to reject the claim. Okay, Regulation 10 speaks about substantiation of the claims. Then Regulation 10 provides that interim resolution professional or the resolution professional, as the case may be, may call for such other evidence or clarification as he deems fit from the creditor for substantiating whole or part of its claim. So whenever if any creditor, so the word used is creditor, so it can include financial creditor, operational creditor, okay, creditor in class, any other. Okay, so if any creditor is submitting the claim, then resolution professional, okay, so he may call for such other information, such other evidences to substantiating the claim that is submitted by the creditor. Okay, then Regulation 11 provides that a creditor shall bear the cost of proving the debt due to such creditor. Okay, so it is the responsibility of the creditor who shall incur the cost. Okay, if any expenses are there, then creditor has to bear the expenses. Okay, then Regulation 12 provides for filing of claims and time limit to file the claims. So a creditor shall submit the claim with proof on or before the last date mentioned in the public announcement. Okay, in the public announcement only, generally we are going to mention the date, okay, within which you are supposed to give. Okay, provided that a creditor who fails to submit the claim with proof within the time stipulated in the public announcement may submit his claim with proof to the interim resolution professional or resolution professional, as the case may be, up to the date of issue of request for resolution plan. So please remember, when you are issuing the public notice, in the public notice we are going to give the date within which you are supposed to submit the claim. But it's not that you are supposed to submit the date. That is not hard and fast rule. Okay, so generally you are having time up to submission of resolution plan. Okay, so you are having time up to the date of issue of request for resolution plan. Okay, so when after the public announcement, after collating the claims, the resolution professional will make a public announcement inviting the proposed or inviting probable resolution applicants to give the resolution plan. Okay, till that time you are having the time, okay, or 90 days from the date of insolvency commencement date, whichever is later. So generally in the public announcement you are having the you are going to mention the time limitation, but the maximum time limitation is 90. Okay, so within 90 days. Provided further that the creditor shall provide reasons for delay, okay, in submitting the claim beyond the period of 90 days from the insolvency commencement. Okay, so as per the rule, you are supposed to submit within 90 days. Okay, if there is any delay is there, then you are expected to, any creditor, whoever is submitting the claim with delay, he is expected to give the reasons for the delay. Then where the creditor in sub-regulation 1 is a financial creditor, then it shall be included in the committee from the date of admission of the, okay, so the financial creditor, whoever is submitting the claim, such financial creditor shall be included in the committee from the date of admission of such claim. Okay, when the claim is admitted, the financial creditor will be admitted to the committee of the creditors, because committee of the creditors consists of financial creditors only. Okay, so whenever if any claim is admitted by the financial creditor, then he will become the part of committee of the creditors. Okay, provided that such inclusion shall not affect the validity of decision taken by the committee prior to such inclusion. Okay, so you cannot say that someone is coming now, so any decision taken before his admission is not valid. Okay, so any decisions taken by the committee of the creditors before admission of this new creditor are valid. Okay, then in the case of Mukul Kumar, RP of KST Infrastructure Limited versus RPS Infrastructure Limited. So in this case, NCLAT held that claims after the time limitation cannot be accepted. Okay, so we are having 90 days time limitation is there. Okay, so if any extended time limitation is there, suppose if any creditor fails to submit the claim within the time limitation, NCLAT held that no, you cannot accept the claim. Okay, why? Because if the claim is submitted after the extended period, okay, so if it is accepted, it is going to delay the entire CRP process. Okay, it is going to affect the entire process. Okay, so that's why you are not supposed to accept the claims, anything which is submitted after the limitation period. Okay, if claim is submitted after extended period, RP should have rejected the claim. Okay, the NCLAT is of the opinion that if claim is submitted after extended period, then RP should have rejected the claim. In another case law, Office of Assistant State Tax Commission, State Tax Department, Government of Maharashtra versus Sri Parthiv Parekh. In this case, NCLAT held that claims cannot be entertained after the time limitation. So clearly it was held that, so even though it is a state government, even though tax liability, but once the public announcement is made, once there is a limitation is there, so you are expected to submit the claim within the time limitation. If any creditor fails to submit claim within the time limitation, please remember such claims cannot be admitted, because it is going to impact the entire process of CRP. Okay, so because the basic objective of IBC is to ensure that CRP process is completed within the time limitation, so that we are going to get the assets. Okay, so maximization of assets is one of the basic purpose of IBC. Okay, so that's why the law is very clear. You cannot accept any claim beyond the time limitation. So regulation 12A provides that a creditor shall update its claim as and when the claim is satisfied. Okay, suppose take the example, if any claim is satisfied, then immediately he shall update it. Okay, partly or fully from any source in any manner after the insolvency commencement date. So once the insolvency commencement is started, if any creditor, maybe some other reasons through other modes, if any creditor is receiving the money, then in such cases, if claim is satisfied, then he shall intimate to the resolution professional. That is what his responsibility. Then regulation 13 provides that verification of claims and list of creditors. So this regulation provides that the interim resolution professional or the resolution professional, as the case may be, shall verify every claim. Please remember, once the claims are submitted in different forms, as already we have discussed, okay, once it is submitted, it is the responsibility of IRP to verify each and every claim. Okay, then within 7 days from the last date of receipt of claim, please remember, once the claims are received, within 7 days you are supposed to verify. Okay, and after that you are supposed to maintain a list of creditors. Okay, so containing the names of the creditors and along with the amount and interest, etc., other details. Okay, why? Because in the form only they are going to give various data. Okay, so like name of the creditor, amount, okay, nature of the interest, etc., all this data must be maintained in the register. Okay, then regulation 14 speaks about determination of claim. So where the amount claimed by the creditor is not precise due to any contingency or other reasons. Okay, so he is unable to, or the amount is not precise. In such cases, the resolution professional or the resolution professional, as the case may be, shall make the best estimate of the amount of claim based on the information available with him. So if the amount cannot be determined, or if the financial creditor is not giving proper picture or proper figure, then in such cases, the resolution professional, he has to use his prudence. Then based on the information available with him, okay, he is supposed to determine the claim. Okay. Then the interim resolution professional or resolution professional, as the case may be, shall revise the amount of claims admitted, including the estimates of claim made under subregulation 1, as soon as may be practicable when he comes across additional information. So already he has prepared the claims. If any additions are there, please remember it is the responsibility of the interim resolution professional or resolution professional, as the case may be, IRP or RP, as the case may be, to update the data accordingly. Then in one of the case law, Rajdeep Clothing and Advisory Private Limited versus Brijesh Kumar Mishra, RP of Krishna Knitwear Technologies Limited, Ahmedabad bench held that the resolution professional cannot delegate the functions. Okay, so from regulation 10 to 14, we are having the powers, as already we have discussed in the previous slides. Regulation 10 to 14, IRP or RP, they are having certain rules. So it was held that these rules, these duties or these powers cannot be delegated, okay, because these are all the functions which has to be delegated by the resolution professional. Okay, so these functions cannot be delegated to other persons. Okay, regulation 15 provides that the claim which are received in foreign currency should be converted into Indian rupees. So suppose if any financial creditor is from the foreign country or the debt is in foreign country, okay, so if any claim is there in foreign currency, then please remember the foreign currency, the claim must be converted into rupee value. Accordingly, the claim must be mentioned. Okay, so you cannot have Indian rupee and foreign currency, both the currency, that is not possible. So whenever you are maintaining the data must be maintained in a uniform basis. Okay, so in Indian rupee only you are supposed to maintain. So with this, we have completed the concept of public announcement, then claims by various people like financial creditor, operational creditor, workmen, etc., and forms related to that. Okay. In today's session, we have discussed about the public announcement, filing of claims and verification of claims. So while discussing the public announcement, filing of claims and verification of claims, we have discussed the provisions of section 13, that is declaration of moratorium and public announcement. Then we have discussed the provisions of section 15, which speaks about the public announcement of corporate insolvency resolution process. Then we have discussed about the filing of claims by the creditor, how to file the claims by the creditors. We have discussed in detail by various categories of the creditors. That is filing of claims by the operational creditors other than the workmen employees. So we have discussed the forms also, okay, which forms we need to use, and when workmen and employees, other than the workmen and employees, if any operational creditor is filing the claims, then how to file the claims, we have discussed. Then filing of claims by the workmen and employee, if any workmen and employee filing the claims, then how to file the claims, we have discussed. Then we have discussed filing of claims by the financial creditor also. Then we have discussed the filing of claims by the financial creditor in class. Then we have discussed about the power of interim resolution professional or resolution professional in relation to claim filed by the creditor. So to what extent he may accept or he may reject, whether does he have the power to accept or reject the claims given by the creditors or not, we have discussed in this class. Then we have discussed the regulation 10 of CRP regulations, that is substantiation of claims. We have discussed the provisions. Then we have discussed the provisions relating to determination of claims under regulation 14 of CRP regulations. So with this, in today's lesson, we have discussed about the concept of public announcement, filing of claims and verification of claims in detail. Thank you.